SJC-13677, Donta L. Lewis versus the Commonwealth.
Okay, Attorney Levin. Welcome back.
Good morning again, Your Honors. Patrick Levin for Donta Lewis. This appeal presents the question of whether an individual who is committed for want of bail, awaiting trial on a charge, is on release. My argument is no, that someone who's incarcerated is not on release. And that's pretty straightforward under the plain language of the statute. The single justice reached a contrary conclusion. She framed the question in the case as whether a defendant is eligible for a bail revocation where he's charged with a new offense that allegedly occurred while he was admitted to bail, but before he had yet made bail and been released from custody. That's not a situation that can exist. Admission to bail means posting bail and being released from custody. That's all it means. I mean, I didn't cite this in the briefs, but the Black's Law dictionary definition says, admission to bail means in order to release an accused person. And the word bail originally meant the person who was responsible, the surety, the person who was responsible for making sure that the defendant returned to court. And what you say is you release that person to bail, you release that person to the custody and responsibility of the bail, and that's when they're admitted.
The reading is essentially when bail is set as opposed to admitted to bail, correct?
Right. But there's no textual basis for that. I mean, there's a textual hook, at least, for the admitted to bail reading, because they do use those phrases interchangeably. But the reason they use them interchangeably is that they mean the same. So there's no textual basis for this construction of the statute.
We don't have any case law to help us on this, right, Mr. Levin?
Well, there's no prior case where this is.
No, but as far as what admitted to bail means.
Oh, I think there is. I cite the Sheriff of Suffolk County versus Purist case in the brief, which cites to the habeas statutes. And so if you look at the habeas chapter, 248 section 19 says, if the prisoner is detained for a cause or crime for which he's bailable, he shall be admitted to bail if sufficient bail is offered, and if not, he shall be remanded, with an order of the court of justice expressing the amount in which he shall be held to bail. And then any magistrate authorized to admit to bail may at any time before the sitting of said court bail the prisoner pursuant to such order. So he's not bailed until he posts the bail and he's released.
I find a little ironic. You're sort of, especially you guys have changed positions here, but you sort of changed approaches too. You're adopting a literal rather than a principled approach. And in Resendez, you did a brilliant job of putting the principle in to give meaning, but you don't want to do that here.
So, Your Honor, I'm going to push back on that because the statute in Resendez, it's not clear what it means. It's the word they chose is confusing. It doesn't make sense.
Let me just push a little bit, and then I promise not to interrupt you. But the principle, Resendez sort of broadened the language to create a principle that seemed to give you a chance to fix yourself.
Right.
And it's sort of, Justice Stewart here sort of does the same thing.
Here's the thing, is that when you look at what the purpose of the statute is, it's to enforce the court's orders, and it's not to punish him for the new crime. And so the question is whether the court's order tells him not to commit a crime while he's in jail, or if the court's order tells him not to commit a crime while he's on release. And obviously it's the latter.
But I get it, but we didn't adopt that kind of very narrowing in Resendez, so it just seems...
you notice that we switched sides here.
Yeah,
but I still represent the defendant, and the rule of lenity still applies. You construe every criminal statute strictly against the Commonwealth. We need a clear statement from the legislature before we deprive someone of their liberty. And so, regardless of the actual extent to which this is a clear statute.
Well, the word release isn't very ambiguous.
Well, that's what I'm saying, is that it's not a very confusing phrase.
Especially when you're in jail.
And I mean, if you look at, this bill also adds to the general laws, Chapter 279, Section 8B, which requires a consecutive sentence for a crime that's committed on release. And so it's the same bill, it's the same language. Is a defendant on notice that he's subject to a consecutive sentence for a crime that he commits in jail when the statute says a crime committed on release? I would submit that he's not.
If we were to agree with you, what are the practical consequences in this, or for this defendant?
There are no practical consequences.
I'm trying to understand, because the chronology stops back in 2024. So I'm just
this bail revocation expired a year ago. This is a moot case. We're just asking you to, because this court has repeatedly recognized that the bail statutes, every case is going to be moot before it can be reviewed.
All right. So were we to agree with you, it would be a matter of reversing the single justice, but with no instruction for anything further to happen, because
in terms of
there's nothing else.
So I guess I would ask you to reverse the judgment and direct an order vacating the bail revocation, just because it is on his record and it shouldn't be. I guess that's in terms of the.
Is that case still pending?
So the underlying case that the bail was revoked on is the same case we were just discussing.
It's still pending?
It's the ACC case, yes. So,
okay.
Yeah.
So refresh me, because maybe Justice Georges remembers, but the bail warning, as I remember it, deals with were you to set bail. There's some words that would logically imply or just clearly apply.
So the warning
inform the defendant that it's when you hit the street.
Yeah, well, in this case in particular, the warning, at least a second time around, the clerk says, if you post this bail and you're charged with a crime during your period of release on bail, then the bail can be revoked. That's what, and I think that's a pretty typical way to give the warning.
It is.
And we should look at this statute in conjunction with the bail warning as well.
Well, the bail warning is the statute. They
Right.
just read the statutory language to the defendant. And so that's what, the statute says the court has to provide as a condition of release that should said person be charged with a crime during the period of his release, the bail can be revoked. And so that's what the clerk, uses to a certain extent, paraphrases, but what they're doing is they're.
I was more getting at that if you post bail part of the warning.
Right. Well, and I think that's inherent. Your bail can't be revoked if you haven't been bailed. That doesn't make sense. And so it's sort of inherent that the revocation can't happen until after the bail has been posted and you've been admitted to bail. If there are no more questions for the court, I would ask you to reverse.
Thank you.
Thank you.
Attorney Morse.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth. I'll just start with the actual warning given in this case. So the operative warning given in this case was the first warning. You are hereby advised that if you are charged with a crime during the period of your release on bail, your bail in this case may be revoked, etc. That is the warning also that tallies with the language of the statute, and so it should be the warning that we're discussing here. And that
What's ambiguous about release? The word release.
So, Your Honor, we think in the context of this statute, in this statutory scheme, release is equated to the way the statute uses the term admitted to bail, and the way the statute uses the term admitted to bail refers to the moment that bail is set, or that personal recognizance is allowed. Although,
Why does that make sense? Because, again, so the whole point of the bail warning is to hopefully get the defendant to comply with staying out of trouble during the pendency of the open case. So why would it make sense that if you're still in a custodial sentence, that goes not only not to the text of the statute when it says release means release, but to the practical effect of it? How can we gauge your compliance if you're still in a custodial sentence?
Your Honor, the purpose of the bail revocation statute is designed so that if somebody is continuing to pose a danger or begins to impose a danger, depending what the crime is, that there's a remedy before the conviction to prevent that.
Sure, while they're on the street, while they're on release.
I think the same analysis applies to somebody who's in custody, because part of the goal is for them to not be harming other people who may be in custody or staff.
But there's another remedy for that, right? So you're looking at, that's not the only remedy that's available to the Commonwealth, this revocation. You can arraign on the new matter. A separate bail can be ordered on the new matter. A separate bail instruction can be, but why would we take this view that in construction of the bail statute this way?
So, Your Honor, when the defendant is arraigned on a new charge, the same statutory scheme that's in place with the original charge is still in place. In other words, the judge gets to set bail at no higher amount than is necessary for the defendant to continue to show up to court.
Sure,
right?
But the person's not held without for 60 to 90 days.
Yes, Your Honor.
So that's a big difference.
My point there being is that in a situation like this, where the crime committed is a violent crime, assaulting another prisoner, but could technically have the element of recklessness, the judge setting bail in that case does not get to consider the fact that the defendant may pose a danger to the community. The purpose of the revocation statute is that the judge does get to consider that when somebody continues to commit crimes.
Doesn't the Commonwealth need to bring that to the judge's attention? Because here, the ABDW and the defendant allegedly committed in custody occurred before the judge held the second hearing on the request to reduce the bail. And the Commonwealth and gave another revocation warning. And the Commonwealth did not file an opposition, at least I didn't see one to that. I don't even know if it opposed it orally. But in any event, it doesn't look like the Commonwealth notified the judge that the defendant had committed an offense in custody.
Your Honor, I'm not sure why the Commonwealth didn't alert the judge. It may have had to do with the fact that the complaint was taken out after the second bail hearing, and so the Commonwealth may not have been aware. But regardless of the circumstances here and the fact that that may have been an alternative remedy available here, it's not an alternative remedy generally speaking. So where this court is deciding essentially a moot question, it should be looking at whether generally a crime committed while still in custody versus not in custody falls under the statute. So here, as both a textual matter, the term admitted to bail is repeatedly used to refer to the moment when a judge sets bail. In fact, it's included in that when it specifies when the judge should be giving the oral bail warning. And that term is also equated, as I mentioned in my brief, in Section 57, it's equated with the term release. And that kind of goes to show that this statutory scheme, although using occasionally what might be colloquially imprecise language, uses language consistently in the statute to show that regardless of whether the defendant has posted bail, that from the moment the oral bail warning is given, the defendant is on notice that they're not permitted to commit more crimes.
Don't we have to go by the plain language of the statute and what the terms are to affect the legislature's intent?
Yes, Your Honor. 2 points on that. The plain language of the statute is read in the context of the statute and the statutory scheme, which is why you get to consider how the term release is used in that statutory scheme. And then, sorry, I forgot what I was going to say.
Is it that the statute uses admitted to bail interchangeably with release? Is that the Commonwealth's position?
Yes, and therefore, and sorry, back to my second point. The term release isn't modified, so it doesn't say release from custody. So although that may be a reading. It could also mean, released from the arraignment session, just to refer to this from that moment forward. If you don't like that reading, that's fine. You can go back to the fact that release is used more broadly speaking to refer to the moment that a defendant bail is set.
Doesn't that back into Attorney Levin's point of the rule of lenity?
No, Your Honor, because the rule of lenity applies when we don't know how to read a statute, not when there's a reasonable reading of the statute that fits with the policy goals of the statute that allows for a more, shall we say, Commonwealth-friendly reading. And so that's why you don't have to apply the
Rule of severity.
No, Your Honor. The reading still has to be reasonable and meet the purposes of the statute. But it does here because the statute or the legislature certainly didn't intend to create a loophole where somebody can assault prisoners and be treated differently than assaulting members of the public. If there are no further questions, we'd ask that this court affirm.